Morning. Who's my registrar this morning? Good morning.
Morning, Judge.
Morning, Justice.
Morning. Good morning to both of you. Clerk of Court, please call the matter.
Good morning. I'm the Register Clerk for this matter. Justice Pillay, all counsels are online. I call the matter of Association of Mine Workers and Construction Union and others, and Anglo Gold Ashanti Limited and others. All counsels are now invited to place themselves on record. Please note that this judgment is being recorded.
My name is Andrew Snyder, Justice, and I appear for the respondents in this matter.
Thank you.
My name is Mairead Edwards, Justice, and I appear on behalf of the applicants in this matter.
Thank you very much. I'm ready to hand down judgment if everybody else is ready. May I proceed? Yes.
Thank you, Justice.
Today, this court hands down judgment in an application for leave to appeal against the whole judgment and order of the Labour Court and the Labour Appeal Court. The Labour Court found a number of intended secondary strikes by members of the first applicant, 20 and 21 February 2019, with a primary strike going on. AMCU served its notice of a secondary strike on the respondents, which are 10 mining companies operating in different mineral sectors. The notice provided for the secondary strikes to commence on the night shift of 28 February 2019 and to continue for 7 days during all other shifts until 7 March 2019. It would involve all AMCU members employed by the respondents. Objecting to the anticipated secondary strikes, the respondents launched separate urgent applications before the Labour Court in terms of Section 66(3) of the Labour Relations Act. The Labour Court consolidated the applications in the gold sector and the applications in the platinum sector, with each sector being heard separately but ruled on collectively. All the respondents argued that the secondary strike would have no effect or indirect impact, no direct or indirect impact on power to influence Zimbabwe's decision to accede to AMCU's demands. They would suffer significant financial harm. Thus, the secondary strikes could not be considered to be reasonable. AMCU, on the other hand, argued that the secondary strikes were reasonable because the respondents and Zimbabwe were all members of the mineral councils and therefore had the ability to place pressure on fellow members in the collective bargaining process. The respondents refuted that claim on the basis that the membership was voluntary and that they concluded separate wage agreements to one another. The Labour Court accepted that the procedural requirements in Section 66(2)(1)(a) and (b) had been fulfilled. The application to declare the strike unprotected therefore turned on the requirement of reasonableness in Section 66(2)(c). The Labour Court held that the test for reasonableness was ultimately a proportionality assessment to determine whether the harm caused by the secondary strike to the secondary employer was proportional to the impact on the business of the primary employer. In this case, the Labour Court, citing the Selga decision of 2007 and the further Labour Appeal Court decision in Selga in 2011, held that the harm was not proportional and declared all the secondary strikes unprotected. Aggrieved, AMCU approached the Labour Appeal Court. However, by then, the primary strike had already been resolved. Despite AMCU's argument that exceptional circumstances existed for the hearing of the matter based on a significant point of law, being the interpretation of section 66(2)(c), the Labour Appeal Court held that the interpretation was already settled in law and proceeded to dismiss the appeal on account of its mootness. Before this court, AMCU submitted that mootness was not an absolute bar to the hearing of this matter. The core of AMCU's submissions was that the interpretation of section 66(2)(c) by the Labour courts, which imputes a proportionality assessment that takes into account the harm suffered by secondary employers, does not accord with the language of the provision. AMCU promoted the interpretation applied in Billiton in the Labour Court in 2001 and Hextex also in the Labour Court in 2002, which prioritize the effect of the secondary strikes on the business of the primary employer rather than the harm to the secondary employers. The second respondent, in essence, submitted that to exclude the proportionality assessment would ignore the distinction between the LRA, a distinction created by the LRA between primary and secondary strikes. The third, fourth, sixth, seventh, eighth, and 10th respondents submitted that AMCU's interpretation would deprive the secondary employer, an innocent bystander, of the protections accorded to it by the LRA. The first judgment, penned by myself with Kampepe ADC J, Madlanga J, Majid J, Mtlantla J, Tlaletsi J, and Tiki J, concurring, holds that the matter is moot, but that it is nevertheless in the interests of justice for leave to appeal to be granted. It considers that a decision of this court would clarify the approach to secondary strikes for parties and others in the labor relations community. The first judgment notes that collective bargaining employs a role, the collective bargaining plays a role in remedying inequality, discrimination, and poverty in the workplace, and consequently, courts must be cautious when interpreting, applying, and limiting the right to strike. It holds in its interpretation of section 66(2)(c) that in relation to the primary employer, a secondary strike must have an effect, and that in relation to the secondary employer, the secondary strike must be reasonable. The first judgment interprets the phrase reasonable in relation to in section 66(2)(c) to import proportionality in assessing reasonableness. It holds that because secondary employers do not have the same procedural safeguards, such as conciliation and more than 7 days notice of the intended strike, that primary employers have, proportionality and reasonableness are shields to safeguard secondary employers. They are needed to preserve the equilibrium that section 66(2)(c) seeks to establish. Further, the first judgment determines that the principle of proportionality derives not from the reasonableness requirement in not only from the reasonableness requirement in section 66(2)(c) of the LRA, but also from the Constitution and international law. In relation to the secondary strikes in the present matter, and purely for the sake of practical illustration, the first judgment holds that they were unreasonable, primarily for having no effect on Sibanye as a primary employer. Additionally, they would have been unreasonably destructive in relation to their impact on the secondary employers. As a result of the above, the first judgment dismisses the appeal against the judgments of the Labour Court and the Labour Appeal Court, except insofar as the costs orders are concerned. The costs orders are reversed with the parties' mutual interest in the matter rendering it equitable for each party to pay its own costs. The second judgment, penned by Jafta J, agrees with the order in the first judgment to grant leave to appeal and to set aside the cost orders in the Labour Court and the Labour Appeal Court. It, however, holds that had the matter not been moot, the appeal on the interpretation of Section 66(2)(c) should have succeeded. It holds that the interpretation of a statute constitutes a process of determining that Parliament meant in a particular provision by determining what Parliament meant in a particular provision by attaching the words used in the provision in question. Words which do not appear in the provision cannot be interpreted, cannot be added to the provision under the guise of interpretation, as the importation of words into a statutory provision falls outside the scope of interpretation. Moving from this premise, the second judgment holds that that Section 66(2)(c) does not expressly limit the right to strike by imposing a proportionality standard for determining the harm caused by the secondary strike upon the business of the primary and secondary employers. On the contrary, the express limitations in Section 66(2)(a), b, and c must be interpreted restrictively so as to have the least intrusion into the right to strike. The second judgment holds that the purpose of Section 66(2)(c) is to regulate the exercise of the right to participate in a secondary strike, the sole purpose of which is to drive the primary employer back to the bargaining table. The impact that the secondary strike might have on the business of the secondary employer is of no relevance to the bargaining process between the primary employer and its workers. Section 66(2)(c) requires only that the secondary strike be reasonable in relation to the business of the primary employer. This would be so if the secondary strike has a possible direct or indirect effect on the business of the primary employer. In conclusion, the second judgment holds that this interpretation of Section 66(2)(c) is consonant with Section 39(2) of the Constitution and demands of Section 3 of the LRA and with the International Labour Organization's position to the effect that secondary strikes should be subject only to the requirement that the primary strike be lawful. The third judgment, penned by Theron J, concurs in the first judgment except on the issue of whether multiple secondary strikes at distinct places of employment can be aggregated for purposes of the inquiry in terms of Section 66(2)(c) of the Labour Relations Act. The third judgment finds that this aggregation issue does not concern whether Section 66(2)(c) prohibits multiple secondary strikes at distinct places of employment from simultaneously occurring. Accordingly, the third judgment holds that the Labour Court made no finding in this regard. Rather, the Labour Court held that for purposes of the Section 66(2)(c) inquiry, a court cannot aggregate secondary strikes to assess the cumulative effect of those strikes on the business of the primary employer. The third judgment holds that the Labour Court was correct in making this finding. It holds that this is so for two reasons. First, the use of the singular secondary strike in Section 66(2)(c) was deliberate and indicates that a court must assess a single secondary strike and thus a single secondary employer in section 66(2)(c) inquiry. The third judgment explains that this conclusion is fortified by the context of section 66(2)(c). In particular, section 66(3) provides that a secondary employer may apply to the Labour Court for an interdict to prohibit or limit a secondary strike that contravenes subsection 2. Since a secondary employer would have no standing to apply to interdict a secondary strike at a different place of employment, secondary strike, as it appears in section 66(3), cannot be construed in the plural. Accordingly, in terms of track principles of statutory interpretation, secondary strike, as it appears in section 66(2)(c), also should not be construed in the plural. Second, if secondary strikes can be aggregated for purposes of the section 66(2)(c) inquiry, this would denude the protection that provision offers secondary employers and thus frustrate the purpose of the provision. The third judgment explains that this is so because by aggregating secondary strikes for purposes of the section 66(2)(c) inquiry, a secondary strike which on its own would be prohibited by section 66(2)(c) could be found to be lawful. Now to the order. The order granted in this matter is the following. Leave to appeal is granted. That's paragraph A. Paragraph B, save as set out below, the appeal against the judgments of the Labour Court and the Labour Appeal Court is dismissed. C, the costs orders in the Labour Court and the Labour Appeal Court are set aside. D, each party shall pay its own costs in the Labour Court, the Labour Appeal Court, and this court. I hand down the judgment.
Judgment will be emailed to the parties and will be available online on platforms such as Supply. Today's proceedings have concluded. The host will now terminate the meeting.
Thank you for your attendance. Thank you.
As the court pleases.